Welcome to today's continuing legal education course. Before we begin, a few housekeeping notes. Your attendance will be electronically tracked. Please engage with the random prompts throughout the course to receive a certificate. A copy of the slides can be found in the Course Materials tab to your right. Presenter contact details are included for any follow-up questions. Upon conclusion of the session, proceed to the Credit tab to complete a brief evaluation. Your certificate will be available for download in the Credit tab after submitting the evaluation. Thank you for choosing Sprout Ed, the leading provider for continuing education for the next generation. Welcome to Addressing Gender Disparity and Power Imbalance Within Institutional Frameworks, brought to you by Sprout Ed. Presented by Rachael Denhollander, attorney, author, advocate, and educator. Thank you for joining. Please welcome Rachael Denhollander.
Good morning. It's a pleasure to be here with you all. My name is Rachael Denhollander. I'm an attorney, an author, and advocate. I specialize in crisis response in abuse-related situations, abuse prevention, and also institutional transformation. This is a topic I am particularly passionate about because I've now had the unique experience in my own case, being the whistleblower in the Larry Nassar investigation, of having been an attorney who is at the mercy of the work of other attorneys and really experiencing in a very firsthand way the incredible impact that attorneys have, both for good and ill. I know, having taken my fair share of CLEs, I resonate with the reputation that CLEs tend to have of being rather dry and not always particularly useful. And I am really hopeful that you will find this course to be both engaging and intensely practical. We're going to cover 5 main learning objectives today. First, understanding the scope of gender disparity, being able to identify how it manifests in legal and corporate and institutional frameworks, and the broader societal impact that gender disparity creates. Second, understanding the relationships between diversity, equity, and inclusion policies, DEI, and how these components intertwine to create a safer environment for all individuals. Third, recognizing power imbalances, understanding power dynamics within institutions and their contribution to inequality and abuse of power. 4, legal and ethical considerations. This will entail a brief review of key laws and regulations and ethical obligations that address gender-based discrimination and power imbalances that it's important to be aware of as we're helping organizations fashion and shape policy or respond to crises. And finally, developing strategies for change, learning practical methods for advocating for systemic change, promoting gender equity, and addressing institutional accountability. Now, given the time constraints, this will of course be an introduction and a bird's eye view only. The goal here is not so much to be exhaustive as it is to create a framework and a foundation that guide our approach and spur us to ask the right questions and bring in the right level of expertise when we're faced with real-world application. Gender disparity, simply defined, is a condition where access to rights and resources and opportunities are unequally distributed between the genders. And often, especially in a politically charged environment, we have tended to treat the idea of gender disparity as a whole, as the product of emotionally fragile individuals with a flair for the dramatic, or a problem that at most maybe exists but creates nagging inconveniences for half the population. It's bad, we don't like it, but it's not that big of a deal, right? But reducing access to rights and resources and opportunities can and does have long-term impact and real-world consequences that go beyond a mere nuisance. And one of the things that I personally find most fascinating as both an educator and a parent is how quick children are to recognize realities that we as adults work very hard to not see. A few years ago, I was talking with my children about racial disparity and describing the practice of redlining during the civil rights movement, the government scheme where geographic districts that were heavily populated by minorities were targeted as a high risk for mortgages and loans and government aid. And it left entire regions underdeveloped, undervalued, and underfunded. And when I mentioned to my children that funding for schools was often tied to property values, without saying anything more than that, my 7-year-old daughter immediately jumped in, and I hadn't made any connections or practical application yet. And she goes, "But Mom, wouldn't that mean that schools where minority children went got less money to use? Wouldn't that mean that they didn't have as many teachers and they didn't have as many schools and things to learn with? And if they didn't have as many schools and teachers and things to learn with, wouldn't that make it harder for them to get a job when they grew up compared to somebody who went to a school that had lots of money? My 7-year-old immediately recognized the long-term generational ramifications of disparity. And of course, racial disparity is a massive topic in and of itself, and I'm not trying to draw correlations between gender and racial disparity. But my point here is that children can often see what we as adults have taught ourselves to not see. Children haven't learned yet all the ways that we excuse and minimize and justify ignoring disparity. And the reason that I am so passionate about this topic is because gender disparity does have significant long-term ramifications on real people. People who could have been helped and people who have been directly harmed by this gap. During law school, my professors would remind us over and over again that our legal training was going to put us in a position where we would be sought out for help regularly. And most importantly, that many times when we were sought for help or approached for counsel, it would be by people who were facing very real suffering and challenges, people who desperately needed help and would be in a very real sense dependent not only on our skill, but on our ethic and our compassion. And the reality is that the world of law and public policy are worlds that are largely foreign to those without legal training. And yet they have incredible real-world life-altering effects on everyone. Effects that can be to a large degree within a skilled professional's ability to control for good or ill. And because this world is so foreign to most, yet has such great impact on daily life, our legal training gives us incredible privilege and ultimately incredible power. Power that we will wield either for pure self-interest and personal gain, or privilege that we will use to better our community and serve those around us. This deeply personal element of legal work is really true no matter what our field is. It might be a client who has suffered an injury and desperately needs help, or a brand new entrepreneur embarking on his very first business venture. It might be advising a large corporation who holds the livelihoods of hundreds of families and individuals in their hands, or crafting policy for an organization or a program that will go on to affect anyone in that institution's path. It may be how we draft legislation or advise an institution facing an ethical dilemma or sexual assault crisis. It might be the skill with which we structure a board or a human resources or Title IX department, and whether that structure that we create will cause an ethically guided work environment or foster unhealth, harassment, or outright abuse. In whatever area of law we practice, in whatever our profession, there are significant real-world consequences on real people from what we do. Our education gives us extensive privilege and power. We have access to justice systems and political systems that we have the skills to manipulate either for selfish gain or to utilize to better the world around us. The communication skills alone that an attorney often possesses position us to have the ability to lead and convince and teach. And how we wield those skills will have significant impact on the people closest to us, our clients, and then also an impact on who our clients are in contact with. And the reality that I've had to grapple with, both through my own case and through the work that I do, is that attorneys are almost always at the crux of what goes wrong or right in gender disparity and injustice. It is attorneys who draft our policies. It is attorneys who create board and administrative structures that will either facilitate corporate health or create power imbalances that foster rot. It is attorneys who determine what steps to take when something has happened that should not have. From the smallest to the biggest problems, the smallest to the biggest changes for good, attorneys are a driving force. And perhaps most significantly, our approach to these issues stems directly from our own internal ethical convictions. Policies and practice are a reflection of our core beliefs. What we as attorneys put on paper, what we take the time to consider and prioritize, is a reflection of both individual and corporate values. What we as attorneys advise and bring to our clients to prioritize has the power to set the moral trajectory of the institution. The power that attorneys have is immense, but it's not immense just on a policy level. Especially when we are discussing questions of justice and disparity, the power we have is immense on a deeply personal level as well. Because the legal profession does place us in people's lives at a time when they are vulnerable, wounded, and grieving. Particularly when gender disparity crosses into sexual abuse or sexual harassment, there is a deeply personal wound that has taken place. And the choice to engage with the HR policies or the Title IX processes that we've designed, or to embark on the pursuit for civil justice, the choice a survivor makes to speak up at all is an intensely personal journey. And the impact of an attorney in that journey is fundamental. For institutions facing crisis as well, there is often a significant amount of fear and anxiety surrounding how to respond to these deep concerns. And our council will either ground leadership in moral courage or facilitate an approach that will continue to move the institution away from long-term health and enable long-term harm. And the last several years of my life have given me a very fresh perspective on what it means to be an attorney, because I have now lived the very unique perspective of being an attorney at the mercy of and on the receiving end of the work of other attorneys. In order to shape effective policies and practices, however, we must first understand the problem and learn just to identify it. Gender disparity crosses into every field and often arises in places where we may not have been taught to see it or consider it. For example, until 1993, the safety and effectiveness of prescription medications was studied almost exclusively in men, though of course women make up half the population. And because female bodies are different right down to the cellular and metabolic level, this resulted in over a century of time where women are now known to have been over-medicated, experienced incorrect medication dosages, and experienced substantially higher rates of severe side effects. Now, in 1993, policy was enacted to require that medications be studied for effectiveness in both male and females. But no effort was made to re-examine the thousands of medications that were studied and approved only in the male population. And a recent study in 2014 found that despite these new regulations from 1993, companies are often still not analyzing or publishing the results related to women, even though they're technically including women in the drug trials, leading to still significant increases in risks for females. Direct provider care also carries significant disparity, with studies finding that women endure over 30% longer wait times for treatment compared to men who present with identical symptoms. And women are also almost 30% less likely to receive adequate pain control compared to men who present with identical symptoms. Women also have high rates of being subjected to unnecessary exams without their consent, exams performed for purely educational purposes that they never consented to, including and especially pelvic and breast exams while they have been sedated and are unconscious for unrelated procedures. The theory that has justified this literally for decades is that medical students need to practice, and not enough women would consent to invasive exams to provide adequate practice. In fact, a recent study by Yale's Interdisciplinary Center for Bioethics found that up to 3.5 million patients reported receiving intimate medical exams while unconscious, without ever having given consent. The vast majority of these were women subjected to pelvic and breast exams while under anesthesia. Additionally, a recent study found in 2021 that over 90% of medical students reported performing medically unnecessary pelvic exams on unconscious women, with over 60% of those students knowing that they did not have consent to do so. Now, at the surface, when we hear this might seem like a problem with individual physicians or medical schools, or an issue that really is confined to the question of medical ethics. But anyone who has done work in any medical field is aware that attorneys have a very significant presence in the medical field. Attorneys create and advise on hospital policies. They create and advise on mechanisms to report failures or violations. They recommend the training and the education to reduce risk and liability. They give counsel on how to respond to concerns or complaints from patients. They help determine how research should be conducted and how it ought to be published to mitigate risk to the researching institution, and so much more. All of these issues that we've just talked through in the medical field alone are directly within the purview of a skilled attorney, though at first glance we may not recognize their relationship to gender disparity without taking the time to understand the context into which we are speaking. And sometimes gender disparity is as blatant as it comes and still left unchallenged. I don't think I will ever forget the shock I felt and the disillusionment as a recent high school graduate when I took a job at my state House of Representatives. And in a conversation with my state representative, the representative I was working for, and staff regarding my future work opportunities, it was casually mentioned by another staffer that any offices I wanted to apply to for a promotion or a more long-term position would need to be checked against a list that the Speaker of the House held. And as I would come to learn in that conversation, there was a significant problem with sexual harassment in this legislature, to the extent that the Speaker of the House literally had a list of male legislators who were no longer allowed to hire female staffers, so that the caucus wouldn't have to be bothered with the fallout of harassment and assault allegations. My employment and career opportunities were explicitly limited in order to protect men who couldn't keep their words and their hands to themselves. And as women experience sexual assault and harassment in educational settings or in the workplace, statistically far more often than men, poorly set human resources or Title IX policies automatically have disparate impact on women more than men. Gender pay gaps, unequal promotion rates, stigmas attached to paternity or maternity leave, HR and Title IX policies, from cultural issues to policy concerns to corporate structures, attorneys have immense impact on gender disparity. But if we don't learn to recognize it when we see it, to ask the right questions, to be proactive in our learning, we will miss what is often right in front of us. At the core, there are two facets to combating gender disparity. There's the prevention aspect. How do we do our best to ensure that we foster justice and do not enable abuse, harassment, or overall unhealth? And second, what do we do when faced with allegations or concerns? How do we respond in a way that is trauma-informed, ethically guided, and leads the individual or institution into moral courage? We're going to look at both of these in turn and consider practical steps for implementation. So first, prevention. Now, the ideal, of course, is that we do the best we can do to create cultures, systems, and structures that foster health and justice. As attorneys, we are bound to act in the best interests of our clients. And if we are going to adopt even the most Scrooge-like approach possible and coldly care for nothing but the organization's bottom line, the smartest thing we will still do is do our best to prevent abuse, harassment, and injustice. We all remember our introduction to civil litigation course: duty, breach, causation, damages. Sometimes bad things happen. But when there has genuinely been no breach, when we have done the best we can do on a policy, structure, and cultural level, we massively reduce, if not eliminate, liability because we have removed the element of breach. Now, I would argue, and we'll later discuss, that a myopic Scrooge-like approach falls woefully short of basic moral codes and ultimately can lead us to harm our own client. But if we're not going to be mature enough to go beyond miserly behavior, we still ought to care greatly about effective prevention measures, because the reduction of risk is in the best interest of our client. And this is where the basic tenets of DEI come in. DEI refers to diversity, equity, and inclusion. Diversity. Diversity is the presence of variety within an organization. Having organizations that aren't comprised only of people from one set of demographics or experiences. And this is critically important because different lived experiences will bring different dynamics to light. No matter how much we want to be sensitive to what others experience, there is a depth of knowledge that comes through lived experience that cannot be replicated even with the best training. So intentionality behind bringing multiple voices to the table and a wide spectrum of experiences is critical in just being able to identify what is taking place, where there may be weaknesses in the organization, and bring together a wealth of wisdom in how we address those. Second is equity. Equity is just doing our best to ensure that people are fairly treated. And this requires two very basic things. First, we have to understand the history and the context into which the institution is operating. We can't address what we don't actually understand. Returning to our medical example, advising a hospital on informed consent policies or methodologies for research can't take into account or combat the reality of women being subjected to non-medically necessary pelvic exams without their consent if we're ignorant of the long-standing history of this practice. if we don't understand why it's been justified, and therefore how to craft policy that effectively addresses this reality. Effective DEI requires proactive knowledge, which again is dependent to a large degree on bringing voices and lived experience to the table. And second, good equity policies will craft structures that both allocate resources and decision-making power to marginalized groups, as well as allow for flexibility to consider backgrounds and unique circumstances to reach fair and just decision-making. A one-size-fits-all approach doesn't work when people aren't cookie cutters. So being able to have the flexibility within a well-defined structure to consider backgrounds and unique circumstances helps us reach fair and equitable decisions. And being able to create decision-making power and allocate that to marginalized groups is incredibly important. Because the reality is we can have lots of voices at the table, but if those voices have no authority and they have no decision-making power, then we haven't done much more than check a box. Power imbalances make it very difficult for marginalized groups to have the safety to speak up in the context where they have experienced or witnessed injustice, because their livelihood, their place in the organization, the seat at the table is still dependent on those in power. Allocating power and decision-making ability to marginalized groups so that those who have a seat at the table are actually equal is integral to effective DEI policy. And finally, inclusion. Inclusion, much more than these first two, focuses really specifically on the culture of the organization. It asks the question, how do we proactively create a culture where individuals feel safe to speak up and individuals are valued? And this again goes back to our moral compass. Our own ethical values drive our policy and our practices. Actions are birthed from ideas. When we create a culture where people are valued and feel safe to raise concerns, then we have created a culture where we can do the best job to keep everyone under that organization's umbrella safe and to ensure that there are not things that we are missing. So the inclusion prong asks the question, how do we create that kind of culture? Now, historically, there have been several key developments in DEI laws that have to guide our practical steps. While there is no federal regulation on DEI principles for private companies, there have been a few key recent executive orders that apply to all federal employees, and some developments in Title VII law that also impact DEI principles. And oftentimes state requirements, though individual and left up to each state, mirror or reflect a lot of these federal requirements. So it will be important that you check each state's requirements and legislative strategy, but having a basic understanding of the federal aspects of it can be important. One of the most noteworthy in the last few years was Executive Order 14035, which was published in June of 2021 under the Biden administration. This executive order does a wide variety of things, but among the most important, it requires that all federal employees conduct specific assessments to accurately diagnose the current state of their entity or their agency related to DEI principles, as well as implement data-driven plans to measure progress in areas of diagnosed weaknesses and the implementation of effective policy. 14035 also carries with it strong recommendations for hiring a chief diversity officer and a number of reporting requirements on data and implementation. While this only directly binds federal agencies, this is no small number of entities which must follow these regulations, and they do provide a level of persuasive authority as to what constitutes best standards practices as well. Around the same time that this guidance was given, however, in 2023, in the court case Students for Fair Admissions versus Harvard, the U.S. Supreme Court struck down affirmative action policies as related to college admissions. Their rationale was that there was a lack of, quote, sufficiently focused and measurable objectives warranting the use of race, that these policies, quote, unavoidably employed race in a negative manner, involved racial stereotyping, and lacked meaningful end data points. And while this case was, of course, specifically addressing racial components and college admissions, the decision and the rationale that affirmative action violated the Equal Protection Clause of the 14th Amendment has led to concerns and threats regarding DEI initiatives as a whole, on the grounds that improper policies or poorly constructed policies have the potential to create reverse discrimination against majority groups. Thus, an area of significant consideration when forming DEI policy is ensuring that the policies do have focused, measurable objectives with meaningful endpoints and do not employ gender metrics or negative or stereotyped metrics in either direction. A very concrete example of this shift is that DEI initiatives must no longer utilize quota or target number metrics for hiring, promotion, and leadership, lest the program as a whole run afoul of Title VII protections. Training under DEI initiatives must be careful to not instruct or suggest that certain groups should be favored or less prioritized. Employee resource groups and mentoring programs must be open to all demographics and may not favor or prioritize other gender. State law is also rapidly changing, and it is critical to stay informed not only about the federal requirements and case law, but also state initiatives and requirements to ensure that policy, training, and reporting is complied with in full. On a practical implementation level, while ensuring full compliance with relevant and state federal laws, an effective DEI program will center around the following 5 components. First, build relationships. Second, gather data. Third, assess and diagnose. Fourth, construct reform. And 5, implement steps. So first, building good relationships. Good relationship building will start with proactive stakeholder engagement. Oftentimes, individuals, including boards and leaderships, are encumbered with so many concerns related to the overall trajectory and function and mission of the entity that DEI compliance can feel like an exhausting waste of time. But effective DEI isn't about checking a box. It's about the overall trajectory of the organization and its core values. But without effective stakeholder engagement, leading individuals towards understanding the core issues of DEI in the context of ethical framework for the organization as a whole, compliance with DEI will be perfunctory at best, ineffective at its worst. Clear communication is critical to achieving corporate health. Wherever possible, take the time to form a group of core, trustworthy individuals who can help guide the goals and the processes and the communication related to DEI. This group should be open to all demographics and include individuals from across the branches and the levels within the organizational structure to ensure both representation and relational connectivity across the broadest spectrum possible. Begin the process simply by building relational bridges to the groups of stakeholders within the organization. Take the time to listen to concerns from across the spectrum. This may be individuals who are deeply concerned about a failure of DEI policies, and this might be individuals who are very frustrated with having to take the time to implement DEI policies. Take the time to hear where your stakeholders are at. And the goal of this first step is simply to begin forming connections in which difficult issues can be discussed and begin engaging stakeholders in the process. Awareness of the perspectives that individuals in the organizations hold on DEI will help guide the type of assessment and reform needed. Oftentimes, listening sessions can help draw out concerns and frustrations and needs, guiding the next steps of the process and helping stakeholders to feel that they have a voice in what is taking place. At this stage, the posture really is to listen and to work on effective engagement of voices. Second, gather data. Drawing from the listening sessions and individuals with expertise in effective DEI assessments, begin gathering data related to the current state of the organization. At this point, it is helpful whenever possible to engage an independent firm with expertise in effective DEI policies and practices. A good assessment will utilize multiple avenues of communication for gathering data, combining a level of in-person interviews or listening sessions, document requests and reviews, well-fashioned surveys, and options for written submissions as well. Oftentimes, the concerns expressed in the initial listening sessions will help guide individuals in knowing what facets might need specific examination or what types of questions are helpful to ask on a survey to effectively identify the state of the organization. A robust and effective assessment will also include a review of policies and procedures, but will also examine the culture and the structure of the organization as well. This is particularly important in complex organizations to consider the different types of expertise that might be needed to conduct an effective assessment. A well-known example of these realities is the Larry Nassar scandal at Michigan State University. During the criminal trial of Nassar in 2016 and in the 2 years following, it was discovered that Nassar's abuse had been reported multiple times to MSU in the late 90s and early 2000s, and then again in 2014 as well. And yet every report failed to stop a serial sexual predator who left hundreds of child victims in his wake and exposed the university to millions in liability. Nassar was reported in at least 4 different athletic departments in the late 1990s, to a softball coach, a track and field coach, multiple athletic trainers, a rowing coach, and the head gymnastics coach at MSU, all of whom received reports of Nassar's abuse from MSU students as well as child athletes who were training under their care. But MSU suffered structurally from what is commonly referred to as communication silos. This often occurs in entities that have no clear communication and escalation channels, where departments are siloed off from each other, operating largely in isolation. So despite Larry being repeatedly reported to multiple departments and leaders, no clear pattern of behavior ever emerged. Instead, each individual and department held their own little piece of the puzzle, handicapping leaders from being able to see that concerns about sexual assault were not isolated incidences, but rather clear predatory behavior. This also meant that when Larry was reported in 2014, when a young woman took the step of filing an official Title IX report against Nassar, alleging sexual assault during a medical exam, none of the prior warnings or data points that should have been available to the Title IX office were even known, because they had never been properly recorded in the past 2 decades. This helped ensure that Larry was once again cleared of sexual assault. Communication silos are just one example of how the structure of an organization can directly feed abuse and unhealth, though we often fail to think of the structural dynamic as related to gender disparity. Board power imbalances are another example of structural deficits in corporate formation that often go unattended to, but which feed unhealthy environments. This too was on full display in the Nassar case, both at Michigan State University, where Nassar was employed, and at USA Gymnastics, the national governing body for the sport of artistic gymnastics, where Nassar served as the team physician for our elite gymnasts. At USAG, during the course of the investigation, it was revealed that a small handful of board members held functional control over any potentially contentious issues, including the handling of sexual assault allegations against coaches or employees. This created an environment where sexual assault allegations against coaches were literally stashed in a file cabinet by a few people in senior leadership, often violating mandatory reporting laws and ensuring that coaches could move from gym to gym and continue abusing, while other board members who might have advocated for a more morally guided approach had little to no knowledge even of the existence of the allegations, much less input into how they were handled. Similar imbalances existed at Michigan State University. A failure to structure the corporate board in such a way that damaging information couldn't be easily siphoned off and obscured paved the way for decades of sexual abuse and one of the worst sexual assault scandals in recorded history. This also reveals a policy breakdown as well. Not only was the corporate board structure ineffective, proper policies on handling allegations of abuse and clear communication channels were never established. Unsurprisingly, both organizations also had and have deeply rooted cultural dynamics, which remained unaddressed and fed a reluctance to draft good policy or to follow what little policy did exist. In the case of Michigan State University, it eventually became widely known that the dean of the department, Larry's boss, was himself a serial sexual predator and harasser who had been reported repeatedly for decades. Yet internal documents at Michigan State University revealed an absolute lack of urgency and care regarding any of the reports received about Dean William Strample. It should come as no surprise, then, that after MSU spent decades ignoring concerns and reports about the dean, in turn, took no action regarding reports about Larry, which did reach his desk. And this happened in large part because attorneys at Michigan State University characterized the dean's sexually aggressive behavior to students as quirks of an older man, and failed to understand the impact his behavior had on the department, students' willingness to speak up, and the disparate impact on women at Michigan State. So a proper assessment will consider the facets of the institution which intertwine both directly and indirectly with DEI, proper document retention policies, perhaps medical ethics and informed consent policies, athlete wellness and safety, Title IX and HR processes, and seek to thoroughly assess the status of each policy. A thorough assessment will also examine the structure of the organization, considering dynamics like power imbalances, board structures, communication silos, and other facets which contribute to the health of the organization, but which may not be immediately thought of as related to gender disparity. And finally, a thorough assessment will include a robust consideration of the institution's own culture, gathering data related to the tone and the approach of leadership, as well as realities on the grassroots level. An assessment of culture must include seeking to understand leadership and grassroots perspectives related to issues that interplay with DEI. How do employees and how does leadership understand power imbalances, implicit bias? What are their attitudes towards rape or harassment or sexual assault? And it is at this stage especially that outside expertise is warranted wherever possible. Individuals who lack trust in the organization will be hesitant to speak with those who are still employed by the entity. And because assessments typically span such a wide gamut of departments and dynamics in complex organizations, bringing in an independent firm who can maintain confidentiality with those who desire it, creating a safe place for whistleblowers and survivors to speak, and who can field a team with the requisite skill sets to assess across a broad spectrum of fields is integral. During this phase, a regular communication cadence should be established and followed so that stakeholders are not left wondering what comes next or where they are in the process, but the process is also not unnecessarily burdensome. The next step of this phase is analysis and diagnostics. Once the data has been gathered, skilled analysis to accurately diagnose weaknesses is critical. And again, the use of independent experts in these fields who come without the implicit bias and emotional connections to the organization, who can focus on policy, structure, and culture is integral. Whenever we are part of a system, it is difficult to see clearly with regards to that system. And oftentimes the data gathering will tell us the what, but skilled analysis is necessary to tell us the why. A few years ago, in the wake of the Nassar case, parents of a high-level athlete reached out to me to express concern regarding abuse prevention at USAG, even following all of the alleged reform that had taken place. Their daughter had been trained by a highly abusive coach, and at one point, at a critical point in the athletic calendar, a high-ranking leader in USAG expressed direct concern in writing to the parents that this coach was putting their daughter at risk, based on the things that he had directly observed. And of course, this coach had access to a number of other athletes. But while he notified the parents, he did not ever file a safe sport report or a complaint or any other record with the governing body who had authority to investigate, or even notify leadership at USAG that he had concerns about this coach. Now, at that point in time, I had the facts in my possession. I had the written communication and I had the what had happened, but I did not have the why. Why did this leader never file a report? Was there a policy gap that created a lack of responsibility that he really ought to have? Did the policy exist, but poor communication and training left him unaware of it? Was his internal thought processes when he chose not to report something that we could address? Was it fear of retaliation, lack of understanding the impact of his role and the ability to support a survivor? Lack of understanding of trauma dynamics and why victims or their families often need help in taking concrete steps? Did he ask someone at some point in time but receive poor guidance, and if so, why? Gathering data tells us the what, but only skilled analysis can tell us the why. And finally, construction and implementation of reform. Once the data has been gathered, and diagnostics have been completed to help the entity identify the why there have been breakdowns or where increased attention would be helpful, effective reform can then be fashioned and implementation begun. At the outset, this may include a recognition of past breakdowns and failures. Oftentimes, organizations want to jump very quickly to the forward-looking piece without acknowledging where there have been breakdowns in the past, but this is a mistake. In order to effectively rebuild trust And to be able to accurately diagnose and to move forward, there has to be an acknowledgement of what has taken place before, coupled with concrete steps that the institution will take to address these specific weaknesses. This should include a robust education and communication plan that seeks to engage the community's core values and advance their understanding of DEI and justice-related issues, while emphasizing the safety of whistleblowers and reporters. Measurable metrics are important to build in accountability, though as noted above, these metrics have to be fashioned in a gender-neutral, non-quota-driven fashion. So timelines and expectations for updating or implementing new policies, creation of support services, and other reform is integral, with identifiable, measurable benchmarks that are not gender-driven. While it is tempting to bypass the effort of effective communication, believing that if the policy is correct, it will trickle down, this is a very critical mistake that institutions often make, because policies and practices are just words on a paper. Whether people will understand them, and particularly have confidence in them as a survivor or whistleblower, or have internal motivation to follow them as a bystander or leader, hinges on the communication of the organization and the tone of the leadership. And sometimes communication really is the biggest piece missing. I recently worked with a client where an assessment phase yielded a very interesting result. Employees reported a very high confidence level in the heart and intentions of leadership, meaning that employees, even down to the lowest levels, consistently reported a strong belief that leadership really did desire to do the right thing. Yet at the same time, employees overall had a very low confidence interval that the right thing would in fact be done. A gap as large as the one revealed in this assessment was unusual, and it was even more so because the policy review found that while there's always room for improvement, the policies and the processes were actually relatively well structured, with some key gaps having already been addressed and several aspects of best standards practices implemented, including the retention of an independent tip line and support services to protect survivor confidentiality and ensure an unbiased process. After analyzing all of the responses received, it was eventually realized that the biggest contributing factor to this gap was simply inadequate communication. The policies and the protections for reporters needed to be communicated more frequently and more effectively, and creating safe spaces for discussions on aspects related to DEI, like power imbalances and assault and harassment, supporting reporters, expressing community grief, needed to be provided intentionally and relationally to help create confidence in a system and structure that actually had been largely well designed. Effective reform will place heavy emphasis on education and communication, seeking to address difficult issues in the context of healthy relational framework, in addition to the nuts and bolts of robust policy and healthy corporate structure. But our actions are merely an overflow of an idea. Policy is only as good as the moral compass behind it. At the core, we will prioritize what we value and how seriously we approach preventing gender disparity, especially assault and harassment, is really a reflection ultimately of our own internal moral compass. But what do we do when our best efforts aren't enough and our client receives reports of harassment or assault? What then is our response? At the core, response, just like prevention, is ultimately a reflection of the moral compass of the institution and the leaders therein. But there are some practical developments to be aware of at the outset. While there is some level of guidance or requirements provided by federal employment law and aspects of state law as well, the most intensive framework many institutions are bound by is Title IX. Title IX governs sex-based discrimination against students, employees, and applicants for admission and employment at academic institutions for all institutions that receive federal benefits. We often think of Title IX as a collegiate or university requirement, but Title IX actually governs any academic institution that receives federal support, right down to kindergartners in the public school system. And given that slightly more than 1 in 4 women report being sexually assaulted during childhood and age 24, while workplace sexual assault is no less common in academic contexts than in other professional environments, Title IX compliance has a massive effect on combating gender disparity. This also means that key provisions of Title IX tend to change rapidly and at times dramatically, particularly between administrations. Currently, just this past April in 2024, the Biden administration made sweeping changes to the Title IX process, including the following. First, it pulled back the requirement for in-person cross-examination that had been put in place during the Trump administration, and instead allowed schools to use written questions or direct examination by the fact finder only in Zoom or live proceedings. This gives the schools substantially more ability to prioritize trauma-informed processes while still protecting the rights of all parties. Second, it requires a school to investigate allegations and provide resources if the conduct limits access to educational resources, compared to the previous requirement that relieved schools of responsibility except when education was, quote, effectively denied. So it heightened the level and the attention to which schools need to take action. Third, it withdrew the ability of the school to arbitrarily use a clear and convincing standard of proof and required that they use a preponderance of evidence standard, except in cases where the university or the academic institution uses clear and convincing evidence as their universal standard. Previous guidelines under the Trump administration had allowed schools to use clear and convincing only for Title IX sex assault processes, rather than requiring a neutral or universal standard. Number 4, it measures a claimant's right to file a report based on whether the claimant was attempting to access educational services at the time of the incident, compared to the Trump administration's previous recording that required that they be attempting to access services at the time of the report. This is particularly helpful in cases of delayed disclosure. Just on a personal level, by the point in time that I even knew Title IX existed, I was no longer attempting to access any services, medical or otherwise, through Michigan State University. Had I come forward during the Trump administration's era of Title IX, I would have never had the ability to file a Title IX report against my own abuser and ensure that he was out of the examination room while the criminal process played out. Number 5, the new regulations in April of 2024 broaden the locations in which assault or abuse may happen and trigger responsibility for the school to respond. And it also requires the school to assess where an incident takes place outside of the school's jurisdiction, but the resulting dynamics create a hostile environment in the school's educational settings. So this might be the type of situation where an alleged rape or assault has taken place nowhere near school property, but the individuals involved attend class together. The school now has a responsibility to consider that allegation and to take action because of creating a hostile environment. And finally, it requires that schools respond with prompt and effective action, whereas under the previous administration, schools only had to show a lack of deliberate indifference. The 2024 changes also require schools to train all employees on recognizing and reporting sex discrimination, with additional training requirements for Title IX officials, and it requires the schools to take proactive measures to prevent sex discrimination from reoccurring, while monitoring and addressing barriers to reporting. Fashioning effective Title IX and HR policies, however, especially where sexual assault is concerned, cannot ultimately be done without understanding the wounds of trauma. Understanding the dynamics of trauma is integral to our crisis response as well. And for those of you who will engage directly with survivors in their pursuit for justice in a litigation or advocacy context, understanding trauma is important and critical to shaping your approach to engaging on a personal level with survivors as well. So for a few minutes, I actually want to step back a little bit and delve into the unique wounds that sexual trauma causes and consider how that shapes our approach to investigations and to crisis response and also to direct survivor engagement. Compared to peers who may have experienced trauma other than sexual assault victims are 3 times more likely to suffer from depression, 6 times more likely to suffer from post-traumatic stress disorder, 13 times more likely to abuse alcohol, 26 times more likely to abuse drugs, and 4 times more likely to contemplate or attempt suicide. And what studies have now also clearly shown us is that the depth of the damage and the ability of a survivor to heal is definitively linked to the response they receive when they disclose their abuse. The depth of the damage and the ability of a survivor to heal is definitively linked to the response they receive when they disclose their abuse. This means that how we engage with survivors when they bring us their stories is absolutely critical, particularly given the reality that much of the time, when a victim reaches out for legal help or to file a report, they have often disclosed their abuse to very few, if any, other individuals. And anytime a victim discloses their story, it is a raw and vulnerable process. How we respond to that disclosure and story is critical in their healing journey. Trauma-informed processes are also critical to ensuring that all information comes forward to allow for a robust investigation. A common myth that is spread about trauma-informed processes is the idea that if we treat a person like they may have in fact had trauma, we've already biased the process. In reality, however, trauma-informed processes are vital to receiving all relevant pieces of information. Trauma-informed doesn't mean that robust investigative modalities aren't used. It doesn't mean that we don't do credibility assessments. It doesn't mean that we don't follow basic and important evidentiary processes. Rather, it means that we engage with reporters in a way that creates safety necessary for them to tell their full stories and engage the processes. Trauma-informed simply means that we bear in mind the wound that trauma causes when engaging with an individual who may have experienced trauma. If you reflect back on the elements of DEI, you will recognize this concept as part of the I part, inclusion. Remember, the inclusion part of DEI asks the question, how do we create a culture where people are valued and feel safe to raise concerns? And as we look at some of these concepts, I'm going to be weaving in practical application for those of you who are engaged in direct client services as well, like civil litigation, as there is much overlap in the content and the approach. So what do we need to understand about trauma in order to effectively walk alongside survivors or craft policies that is safe for them to engage? While everyone's experience is certainly unique, there are some common threads to be aware of. First is a deep sense of shame and guilt, often feeling the need to be punished. For many survivors, this further manifests in suicidal thoughts or self-harming behaviors like cutting or intentionally destructive risk-taking behaviors. A significant part of this dynamic is an attempt to regain control. Victims will often take partial or total blame for the abuse they have suffered because subconsciously it feels like if there's something we can do differently the next time, perhaps they can be safer. And since society often also illegitimately places blame on victims, what were you wearing? This is a struggle every survivor will face. On an intensely practical level, this means that it's not uncommon for survivors to have disclosed the abuse or talked about the abuse in a way where they have assumed a level of consent and blame, even if there was no consent at all. This can often be a result of the confusion that follows assault, the cognitive dissonance between who this person was supposed to be and what they have now done, but also a subconscious absorption of the guilt. Because if a survivor can assume a level of responsibility, they have a chance of convincing themselves that if they just consented, maybe it was partly their fault, then there's something they can do differently next time. There's a chance they can keep themselves safe in the future. And it helps guard us against recognizing how intensely vulnerable we really are. Sometimes for survivors, this looks like engaging in further sexually abusive or abusive relationships. Not infrequently, this includes living in a cycle of abusive relationships or becoming very sexually aggressive. Nearly every sexual assault victim struggles at some level with a sexual manifestation of the damage. And oftentimes, again, this is an attempt to regain some form of control over their sexuality. To many survivors, it feels like if they can initiate encounters, even very unhealthy or abusive encounters, it feels like they are wielding their sexuality rather than having it constantly wielded against them. In a Title IX or an HR context, these are dynamics that are often misunderstood and improperly categorized or weighted in the assessment. While we absolutely have to examine and consider these dynamics, far too often they are just automatically taken as evidence that a story has been concocted or there was night after regret, without realizing that these dynamics often are, in fact, tangible signs of trauma. Failing to understand these dynamics can result in reaching inaccurate conclusions, but can also create a chilling effect on reporters. I actually recently met with an attorney who had been hired to do an independent investigation at a local school related to an allegation of rape brought by a 15-year-old girl. The rape had reportedly occurred 5 years earlier on school property when she was 10. And as I sat there with the reported victim's parents, the investigating attorney informed the parents that he had reason to doubt their daughter's allegations because why had it taken her so long to report? But in reality, delayed disclosure, especially in child sexual assault cases, is the norm, not the exception. And 5 years is a notably short window for disclosing child sexual assault. The average age of disclosure for child sexual assault ranges between 45 and 54, depending on the study that you look at. If the vast majority of child sexual assault cases are delayed disclosures, then properly understood, a delayed disclosure isn't potential evidence of a lie. It's exactly what you would expect to see in a child sexual assault case. This doesn't mean you don't examine corroborating evidence and perform credibility assessments and ask what was taking place in the last 5 years. It doesn't mean you don't engage in robust investigative methodologies. It does mean that a properly trained investigator will not improperly categorize evidence. As you can imagine, this had an immediate chilling effect on this little girl's parents and on herself to be directly confronted with what amounts to a rape myth as she's being asked to trust this independent investigator with the most intimate details of her life. Trauma-informed investigative processes are integral to ensuring safety for the full story to come out. In a civil litigation context, these are likewise dynamics that are often wielded against survivors, and which we as attorneys must understand and be able to explain, and to prepare our clients to be able to explain. Survivors often feel intense shame and guilt over these trauma-based behaviors, and frequently have not yet unpacked all of the reasons for why those behaviors even exist. Being able to answer when these realities are weaponized and prepare our clients to understand their own responses and their stories, learning to understand these dynamics and being able to properly categorize them helps them understand themselves. Learning to explain it helps move these truths from head knowledge to embraced reality, an integral part of a survivor's healing journey. Understanding and being able to defend against the weaponization of these realities is a critical component for civil litigation or criminal process, but even more importantly, is a critical component of survivor healing. Trauma wounds for many survivors often also include PTSD manifestations, anxiety, panic attacks, and flashbacks. And the best way we can really understand what those are and how they inform our guide our policy and our processes or our survivor engagement is to really look a little bit at the neurobiology of trauma. I was recently watching the movie Inside Out 2 with my children, and one of the parts that I find most relatable is when the little gremlins that are running around in the main character's brain find the little memory marble that contains the commercial jingle for a gum commercial, and they shoot it up the pipeline, and she starts automatically humming this little jingle. And all of us can relate to things just popping into our heads at points in time when we're not always sure why they do, and then it just gets stuck there, and we hear this song over and over. And that's Pixar's way of trying to explain the concept of memory triggers, how memories work. But triggers actually are a real thing because our brains and our bodies are constantly forming neural pathways in response to the sensory input we are experiencing. What we felt and heard and smelled and tasted during an experience that we had becomes part of the neural pathway to access that memory. And the more vibrant that memory, the more shocking that memory, or the more continual that memory, the stronger that neural pathway. So a very funny example of this is that I love the smell of pot roast because I grew up in cold Michigan, and oftentimes on Sunday we would go to visit my grandmother. And I have the most vivid memories of walking out of the cold Michigan winter into the warmth of my grandmother's kitchen and smelling the Sunday roast that she had made for dinner. And when I smell pot roast, I remember my grandmother. And because my grandmother was a safe person, I can't help but smile, right? I remember all the things that I experienced when I walked into her kitchen. I remember the warmth of her kitchen and the sound of her voice when she would turn around from the kitchen sink, "I'm so glad you're here," and the softness of her hug and the smell of her perfume. And when I remember my grandmother, I feel joyful and happy because my grandmother was safe. And I don't tell my brain when I smell pot roast, "Brain, pot roast reminds you of your grandmother was safe, please release serotonin and dopamine and feel happy right now." I don't tell my brain and body to do that. My brain and body do that automatically because that's how we were designed. That's how it works. And if you think back to a positive childhood memory, you will most likely, like I do, see it playing in front of you, almost like watching a movie. It might be a very high definition movie or memory. You will likely recall and maybe even feel some of the memory or the emotion that you felt, but it's a largely two-dimensional experience, somewhat akin to watching a movie that's emotionally engaging. But research tells us that traumatic memories are stored and accessed differently in the brain. When a survivor re-experiences these memories surfacing, they're not experienced in two-dimensional form. In fact, the brain scans of a trauma survivor that are experiencing traumatic memory recall look very similar to the brain scans of a stroke patient. Entire regions of the brain that should be lighting up have entirely shut down, especially the region that processes verbal output, being able to communicate clearly, and auditory input, being able to hear and process what's going on around us. Whole regions of the brain have shut off in traumatic memory recall, while certain regions of the brain, especially the frontal lobe, which processes current sensory input, has lit up. Now, that area of the brain shouldn't light up in memory recall, but it does when traumatic memories are recalled. And what this means is when a survivor recalls a traumatic memory, it's not processed in the area of the brain that says, hey, this happened and it was really hard. It's processed in the area of the brain that says, this is happening right now, which means that oftentimes traumatic memories are recalled as an immersive full body experience. Survivors don't remember what they felt, they feel it again. They don't remember what they heard or they smelled or they tasted. They re-experience those realities again, oftentimes to the point that it becomes so immersive they need help coming out of that memory and reorienting themselves to reality. Many survivors will hold cold objects or ice cubes to try to feel reoriented to their surroundings. Oftentimes, they will need the help of someone next to them to come out of that traumatic memory recall. And as you may imagine, these flashbacks are very traumatic. Just like I don't tell my brain to release serotonin and dopamine when I recall a positive memory, the recall of traumatic memories causes a cascade of fight and flight hormones in a survivor. I have 4 wonderful young children, and they like to play this universal childhood game called Let's Scare Mom. And if you have ever been around children or you were a child once yourself, chances are you played that game too. And you have experienced the reality of being jump scared. That's what my son calls it. And so what happens in that moment, right? When one of my kids jumps out from behind a closet door or behind a wall and startles me, what happens in that moment? My heart immediately starts to race. My stomach clenches. My skin gets prickly, right? I have this immediate sensation of something's not right. That's my body releasing cortisol and adrenaline to tell me something's not safe. Get ready to protect yourself. Now, very quickly, I realize that it's just one of my children and I start planning my revenge and I'm still ahead and I'm still winning. And my body balances out quite quickly. Right? The cortisol and the adrenaline, they shut back off. The serotonin and dopamine start back up again and we all have a good laugh about it. But in traumatic memory recall, that cortisol and adrenaline are pumped out over and over and over again. And because survivors experience flashbacks so regularly, oftentimes their body no longer shuts off the cortisol and adrenaline. They live in what we call a state of hypervigilance. That feeling that you get in the moment that you're jump scared before you realize that it's just your child or just your buddy. That's where survivors live all the time, with a constant feeling of something's wrong, it's not safe. Life in general looks very different for a survivor of abuse. Things that others won't give a second thought to can be threatening to an abuse survivor because the survivor is intensely aware that seemingly innocent conduct or contact is often wielded like a weapon. Most abuse is perpetrated by someone the victim should have been able to trust or knew through some level of relational context. 93% of sexual abuse takes place in a relational context. What I want you to understand through a glimpse of the damage is how severe it is, and how much creating effective policies and processes that survivors can safely engage or walking with a survivor as they pursue justice requires understanding these dynamics so that we can fashion systems and structures and cultures where it is safe for a survivor to raise their voice. And creating cultures and processes which survivors can safely engage, where a full investigation can take place, is critical to abuse prevention as well. Abusers are skilled manipulators, and they often seek out communities where they know reports of abuse are less likely to be taken seriously, or create dynamics where they know it is less likely that a report will be taken seriously. Abusing where people are nearby, abusing where it appears like the victim could have gotten away or gotten help if she had wanted it. Trauma-informed engagement processes means that we bear these realities in mind as we shape the policy and the structure and the culture of the organization. At the core, healing is the inverse of the damage that's been done. If you break a bone, you need the bone to unbreak. If you sprain a ligament, you need the ligament to unstretch. If you have pneumonia and your lungs are inflamed, you need the inflammation to go down. Healing is the inverse of the wound. For individuals who are engaging with survivors, particularly in direct client contact, we are in a very unique position to have the opportunity to be the inverse of the wound that was suffered in abuse. In the context of Title IX and HR policy, this doesn't require losing objectivity. It does require crafting processes and training investigators in a way that seeks to be the inverse of abusive dynamics, so that we are not re-traumatizing survivors in the process, and we are creating effective processes whereby all the evidence is safe to actually come out. Sexual violence almost always takes place in interpersonal dynamics, and the legal profession likewise centers on interpersonal relationships. In an attorney-client relationship or a Title IX process, a survivor has to tell their story and entrust their counsel or their investigator with the most painful moments and intimate details of their lives. And how we engage with these stories will communicate powerfully to those who have been suffered, even in structures where objectivity is nonetheless required. Understanding the damage that comes from sexual violence, then, helps guide our interactions. In sexual violence, victims experience a loss of voice. They're unable to fight back. They're overpowered or manipulated. Their voice or their expression is stripped from them. When we understand this, it guides us to prioritize a victim's voice and to seek to draw it out rather than drown it out. We can seek to restore survivor voice by creating safety when they tell their stories. And for those who are directly representing survivors, seeking out their perspectives intentionally, validating their voice and that their perspective matters to the legal team are critical components of survivor engagement. Attorneys tend to have very strong personalities and very strong opinions. And in the context of representing survivors of trauma, it is imperative that we pause, we step back, and we seek to intentionally draw out and support survivor perspective and agency. In sexual violence, survivors experience a loss of agency as well as a loss of voice. Not only is their voice not heeded, but their choices and their decisions are stripped from them or overpowered. They are used as pawns for someone else's end goal. Understanding this reality helps guide us to be incredibly intentional about preserving a survivor's agency and choice to the greatest extent possible, seeking it out and honoring it, communicating clearly and without ulterior motives. On an intensely practical level, the following items are foundations of healthy survivor engagement. First, clear communication. An abuser manipulates communication, isolates survivors, and withholds knowledge in order to facilitate abuse. And when we remember that any sensations or dynamics which mirror abusive dynamics can trigger trauma responses in the survivor, it helps us understand why communication is so critical. Failing to communicate clearly with the survivor, causing them to wonder, what am I missing? What comes next? Is something happening that I don't understand? Can mirror the feelings of confusion and uncertainty that they experienced during the abuse or in the aftermath of it. Setting a regular communication cadence with survivors, whether that's in the context of Title IX processes or representation for civil litigation, is critical. Keep them informed of the status and the expected next steps to help minimize feelings of confusion and uncertainty. Because the legal process is foreign to most survivors, take the time to explain what's going to take place, the various steps and stages, the big picture, as well as the specific items. This not only minimizes triggering sensations of confusion and uncertainty, but it also equips the survivor with the knowledge needed to be an active participant in the process, so that their agency can be centered and full-throated consent to engaging with those dynamics can be given, especially when decisions about the case need to be made. Be honest about realities. We never make promises that we can't keep. Make sure they understand the potential steps in the process. Survivors should never be surprised by something that takes place in the Title IX process, or in the case of litigation, a deposition or a defense that gets raised. Know and explain well the various processes and what they can and can't accomplish. A survivor should understand from the beginning what outcomes the Title IX process might have and the limitations on it. Similarly, in a civil litigation context, a survivor should thoroughly grasp what a civil case is capable of accomplishing and what objectives they might have that litigation really can't meet. Keep guiding them towards the reality that their healing must be independent of the outcome of their case. In the Title IX context, where objectivity must be maintained, this is best done through connecting survivors with resources, advocates, and therapists who can walk with them on their journey to healing. For litigators engaged in direct survivor representation, we have the ability to engage on a much deeper level in our clients' healing journeys. And it is absolutely critical that we never tie our clients' healing or their value or the reliability of their story to the outcome of their case, but rather continually point them to the reality that their truth, their identity, their value, and their healing exists independent of what anyone else says, including what is said in a settlement or a trial. In these processes, we center survivor agency and voice. Where it is possible for survivors to have choices, provide them. In the Title IX context, this might be as simple as asking questions like, would you prefer the door open or closed? Reminding them that they can have a support person and encouraging them to make use of resources. Asking if they have questions and being willing to spend the time necessary to communicate well. Title IX regulations require institutions now to provide a level of support services for reporters, and this is a very wise step for litigators to consider as well. Connecting survivors to resources helps ensure that they can be in the healthiest place possible to make decisions about their case, whether that's the Title IX proceeding or civil litigation. Encourage survivors to utilize those support services and engage in therapy if they are not currently with a good therapist. Be prepared to point them towards what good therapy looks like. Wherever possible, maintain a referral list or an employee or independent contractor, especially in the civil litigation context, who can assist with connecting survivors to local resources. This helps provide effective care for survivors while maintaining appropriate professional boundaries for you as well. In the civil litigation context, know the lies that a survivor will hear in their own head and speak the truth to them at every possible opportunity. Walk them through understanding biological responses like fight, flight, freeze, and fawn. I can't tell you how many survivors have come to me and disclosed quote-unquote consensual abuse. And then when they begin to describe what they've experienced, what they're actually describing is violent felony level assault, because they misinterpreted their own body's freeze response and their self-preservation as, I guess I must have wanted it because I stopped screaming. I guess I must have wanted it because I didn't fight back. Understand these neurobiological realities and be able to walk a survivor towards understanding them as well. In the civil litigation context, understanding your client's goals and being prepared to fight for those goals skillfully is critical. Non-monetary reform is an incredibly important component of institutional transformation. Do you know what to ask for? Do you know how to fashion non-monetary reform in a skilled way so that the language included in a settlement agreement actually does what it needs to do to be effective? Where possible, discuss the theories of the case with the defendant. I have someone I'm walking with right now who is actually being sued by an abuser for alleged defamation. And we are faced with this reality where the defamation case can be defended based on a technicality, and we would probably win. Or we can go to the underlying issue. She was telling the truth. And that is a decision that has to be made intensely collaboratively with the survivor. Sometimes the goal is not just winning the case. In this particular situation, the goal is the validation of what she's experienced and the ability for her to be able to speak freely about her story, something that we can't obtain if we argue the case only on technicalities. Understand the goals of your client and involve them in the decision-making process on the theories of the case. Your client is not your pawn, and they're not your tool. Look long-term to the good of your client. NDAs are an area where this has become an intensely problematic dynamic. It is not uncommon for survivors to not understand the implications of signing an NDA or be at a point in time when they reach a settlement that they can't imagine ever wanting to speak publicly about their abuse. But 10 or 15 years later, when they have journeyed farther and they have healed more, then they want to begin engaging in advocacy. They want to be able to tell their story, and they are now faced with the reality that their voice was stripped from them again. Look to the long-term goals of your client and be able to help explain those things to them. Fight for the long-term health and the long-term vision. Understand the goals of your client and how multidisciplinary processes might be involved. The criminal process, the Title IX process, or the safe sport process. Oftentimes I have survivors who approach for litigation help, and their main goal is, I don't want this coach to be able to coach anymore. Or I don't want this teacher to be able to teach. I want this person to be on the banned coaches list. And the reality is that civil litigation can't accomplish that. There are a lot of other things that we can accomplish through civil litigation, but civil litigation doesn't put somebody on a banned coaches list in most contexts. And it doesn't even play out publicly enough that anyone would know that it's taken place or that the survivor has been able to, quote unquote, prove their case in court. And so wise engagement of multidisciplinary processes so that you are caring for the whole facet of objectives for your survivor is critical. Your clients and your cases are not your trophies. They're people. They're not means to an end. They're not a pawn, and they're not a tool. Understanding the goals and objectives that survivors have in the litigation context is critical to centering their agency and voice. Perhaps the most difficult aspect to address, however, is what to do on an institutional level when a crisis hits. What do you do in the moment that you look at something your client has brought you and you realize, we have a problem? And this is where the decisions made long before, the decisions about core values and moral trajectories, become so intensely critical. At that moment, when we realize we have a problem, there is an immediate instinct to want to minimize that problem, to make it less serious, to categorize it differently, to find reasons why it couldn't have been prevented, the entity couldn't have known. The immediate instinct is usually a desire to minimize and obscure. When an institution is faced with crisis, they can take one of two basic approaches. First, they can acknowledge what took place or allegedly took place, and that those allegations are inconsistent with the values of their organization, and immediately take concrete steps to accurately evaluate the allegations and diagnose any failures that led to current problems, proactively engaging in validated survivor care and pursuing accountability and transparency. The organization can choose to say, what's been reported to us is not okay, and we are going to do everything we can do to understand what happened so that we can do better in the future. Or an organization can view survivors and whistleblowers as an immediate threat and a potential risk, immediately adopting an adversarial approach and dehumanizing the people who have raised the concern. And the latter is unfortunately the perspective taken in most cases. Often this stems from a twofold problem. First, a very myopic approach to the concept of fiduciary, and second, a miscategorization of survivors. As attorneys, we are all bound to act in the best interest of our client, but more often than not, we are taught to think about this concept in very one-dimensional terms. Protect the upfront monetary cost. The reality, however, is much more complex than that. The organizations we are tasked with serving are much more than the upfront cost that might take place if they acknowledge when something went wrong. Our organization has a reputation. It has a place in the community. It has donors. It has stakeholders. It has a mission and goals and objectives. And when we distill best interests down to protect upfront cost, we have failed to consider the entity's long-term vision and goals and mission. Often entities embark on concerted efforts to simply manage risk and image, which only serves to emphasize to stakeholders that the organization might not be a place that shares its values and may no longer be a safe place. And a refusal to accurately diagnose failures and breakdowns also ultimately makes it impossible to fashion effective reform, leaving institutions open to repeated scandal and liability. We cannot fix what we will not diagnose. And the longer institutional weaknesses are left unchecked, the greater the risk to the organization. This approach also dramatically misunderstands the heartbeat of survivors. Survivors of trauma are desperate to ensure that no one else has to live through what they have lived through. More often than not, they desire to be part of the solution. And what is most important to a survivor is simply the truth. Tell the truth about what happened to me. Figure out how it happened, and let's make sure that it doesn't happen again. An approach that views survivors as liabilities and adversaries and dehumanizes them rather than seeing them as hurting people entirely misses the humanity of those who have raised the concerns or allegations. And whenever we miss our humanity, we don't make wise decisions. Michigan State University and the Nassar scandal is again a case study in poor crisis response. For the first 5 months after allegations were raised against Nassar, board members publicly derided survivors, referring to them as ambulance chasers looking for a payday, despite the fact that almost no one had taken any legal action or even threatened it at that point in time, and utterly ignoring the reality that damage had been done to literally hundreds of children and students. At one point, the president of the university expressed a desire internally to reach out to survivors and simply make contact or make a statement that demonstrated the seriousness with which she felt the school must approach these issues. But legal counsel at MSU insisted that the worst possible step that could be taken was to express grief. Sexually abused women and children were seen as adversaries instead of as people. And for the next 3 years, MSU steadfastly refused any genuine diagnostics, no independent assessments or accountability with any credibility or proper scope or work product designed. As a result, many of the problems that were identified as breakdowns that led to the Nassar case have continued to this very day, repeating themselves in the university a full 7 years later because we cannot fix what we will not diagnose. The board and even the presidency has turned over repeatedly as problem after problem has continued to plague the university. Additional liability was created and significant goodwill was lost, resulting in MSU now becoming a byword, literally, for how to do it wrong. All because legal counsel adopted a myopic and short-sighted approach, choosing instead to view survivors as adversaries and utterly bypassing any human element to crisis response. 7 years later, MSU is still a headline as the failures they refuse to diagnose continue to repeat themselves. Crisis response, more than anything, draws out our core values and forces us to consider what we care about the most. What will be our client's moral compass and ethical framework? What values will drive the organization? And will we have the moral courage to hold to those values when it matters the most? At the core, whenever we go to make a decision, we are pulling out a proverbial scale. And on one side of that scale, we are placing a set of interests, something that we want to protect, maybe upfront costs, something that we're afraid of, liability or loss of reputation or litigation risk. On one side of the scale, we're placing a set of competing interests. And on the other side, we're placing the people who will pay the price for the choice we make. And we're deciding which one we care about the most. The victims who will either be responded to redemptively or whose trauma will be compounded. The safety of the students and employees and other individuals under the care of an organization with massive failures and therefore still at risk. On the other side of the scale are the interests, and we have to decide which we care about the most. If we are committed to a value-centered, ethical framework, however, our crisis response will entail a few key components, and then with this we'll wrap up. First, a thorough communication strategy that reflects the values of the entity and communicates the seriousness with which injustice will be treated. This does not require stating conclusions about the allegations at the outset. An independent process does need to play out, but rather it communicates our values surrounding the allegations and how our values will drive the approach to responding to them. Second, a robust, transparent assessment process that is safe for victims to engage. We cannot fix what we will not diagnose. And if we cannot tell the truth about what has taken place, we cannot expect to regain trust or even effectively prevent future crises. An approach that is more concerned with immediate risk mitigation rather than long-term abuse prevention signals to everyone in the organization that if they abuse, or they enable, or they fail to follow policy, there will be little to no consequences because we're more concerned with the upfront mitigation risk than the long-term change. It would cost too much to tell the truth about what went wrong. And once that message has been sent, we have created a culture where the best policies may exist on paper, but the motivation to follow them has been absolutely gutted. Instead, a commitment to a robust assessment process by a skilled and qualified firm to assess the policy, the culture, and the structure to accurately diagnose breakdowns that led to the current crisis is critical. This must be performed by an independent firm, ideally a firm that specializes in ethics and compliance and institutional transformation, with a robust team that is truly trauma trained and pulls together the range of expertise needed to accurately diagnose breakdowns. A properly scoped process will have strict measures put in place to tightly protect survivor identities and personal identifying information, and to ensure the genuine independence of the firm. Metrics will be put in place to assess compliance with the assessment, and where possible, appropriate survivor support mechanisms provided for. The scope should allow for the firm to accurately report what the evidence demonstrates, regardless of whether high-ranking leaders engaged in aspects of the institutional failure. The assessment should culminate in an independent written public report and include recommendations for effective institutional change. At the core of institutional courage and at the heartbeat of every survivor is simply tell the truth. Just tell the truth. A public written report with recommendations for change gives the institution and stakeholders and survivors information to coalesce around and practical steps to move forward in unity. But this is a step that can only be taken when we have first been honest about the past. Gender equity, DEI, Title IX, Title VII, all of it can feel very complex, and at times, honestly, it is. But at the core of all of this are our ethical values and our moral trajectory. Actions are the overflow of ideas. And my hope is that as you encounter these realities in your professional and daily life, you are able to view them not as a burden or a box to check, but rather as an opportunity to engage, to speak to the core values of individuals and institutions, and engage on an issue with deeply personal impact. Thank you. I think we've got just a couple questions here. Hi, question 1. As a society, do you think we're making acceptable progress, and where do you think things go from here? Yes and no. I think on a conversation level, we have made great strides in the last several years. I'm encouraged by the conversations we're having, the length and the duration of them. At the same time, what I think you do see when you look across the spectrum is a lot of rape myths still being utilized and reported. I think there's a sharper divide happening. We're seeing a lot of individuals that are doing a much better job, and we're seeing a much harder backlash to these ideas, right? A much greater push against DEI and gender disparity types of discussions. I think what comes next is a couple things. Again, continuing to push on the policy level, continuing to have some of the very hard conversations we need to have, particularly as attorneys. What is our duty to the organization when a crisis hits? How do we negotiate those dynamics? I think is going to be absolutely critical. And in addition to that, conversation really is what drives cultural reform. And so the more we can engage on these discussions, the more we can educate, the more we will be able to drive effective change. All right, and I think that is all the time that we have today. Thank you all. I greatly appreciate your taking the time to be here. Thank you to Sprout Ed for making the place for this discussion. And I hope as you re-engage on a professional level, you will find this course to be both useful and intensely practical.